Welcome to the IAPP web conference, GDPR Data Subject Rights, Handling Requests from Third-Party Platforms. My name is Dave Cohen. I'm the IAPP's Knowledge Manager. I'll be your host for today's program. We're going to get started with the presentation in just a minute, but before we do, I'd like to share with you a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. Others who are listening in can apply for those credits through an easy-to-use online form that's on our website. We'd also like to remind you that today's program is being recorded and will be provided free to registered attendees approximately 48 hours following the live event. We encourage you to ask questions at any time during the program by typing them into the Q&A field that's just to the right of your PowerPoint window. And your questions will be answered by the presenters at their discretion either during the presentation, but more likely during a designated question-and-answer period just after the presentation. Also want to let you know if you're interested in getting a copy of these slides that you can either email me, and my email address will be available at the end of the program, or there will be a live link where you can download them from the IAPP website just below the window through which you'll view the recording of the program. Now on to the presentation, and I'd like to introduce today's panelists. Ulrika Del Rude is the Global Chief Privacy Officer at PayU and also a member of the Women Leading Privacy Advisory Board and the Certification Advisory Board here at the IAPP. Ulrika, welcome to the panel. Thank you so much for your time today. And can you tell us a little bit about your post over there at PayU?
Sure. Thank you, Dave, and hi, everyone. Yes, so I am the Chief Privacy Officer of PayU, which is an online and mobile payment services provider active in the fintech space. And we are a truly global company operating in emerging markets mainly, in Latin America, in Africa, in India, Southeast Asia, Europe. And the reason I mentioned that, the global aspect, because that will have a bearing on the discussion we'll have a little bit later today. I'm based in Brussels, in Belgium. I'm Swedish, and both Swedish and US qualified lawyer. I've been with PayU for just 2.5 years, but my experience in privacy stretches a little bit farther than that. I think I've been active for about 20 years, mainly worked in many global US or other international companies. I've been with GE, Oracle, Novartis, to mention a few. But then, as you mentioned, I'm also have been an active and avid member of the IAPP, certainly since its infancy in Europe, and served on a number of boards, and now happy to be on the Women Leading Privacy Advisory Board and the Certification Advisory Board. So thanks for that.
Excellent. Thank you so much, Ulrika. Let me publicly take this moment to thank you for your great service over the years on many advisory boards and at all of our events. So thank you for all of your great volunteer service to the IAPP. It's very much appreciated. And joining Ulrika on the panel, Carolina Foglia is Legal Officer for the European Data Protection Board, the EDPB, which many of you on the line are familiar with. Carolina, it's wonderful to have you with us as well. And can you tell us a little bit about your post over there and also your previous professional experience?
Absolutely. Many thanks, Dave, and hi, everyone. Indeed, I am now working as a legal officer at the Secretariat of the European Data Protection Board. Before joining the EU institutions, I used to work as a lawyer. I am a qualified attorney in Italy and in New York. And then after a few years in private practice, I decided to move on to a career in the public sector, more oriented towards policymaking. So thanks so much for inviting me to participate in this panel today. It is extremely interesting for me to look at the interplay between the guidance that we at EDPB are trying to provide, and on the other hand, the challenges faced by companies and individuals in applying the GDPR. This is extremely fascinating for me, so thanks a lot.
And thank you, Carolina. It's great to have you with us today. Joining Carolina and Ulrika on the panel, Anna Padaraki is Senior Associate with Hunton, Andrews & Kurth, also joining us from the EU today. And I will make mention of the fact that Anna is one of the organizers of this event and helped put this program on earlier for a virtual IAPP KNet and then brought it to us as an idea for a web conference. So Anna, I want to thank you for your leadership and organizing of this topic and this panel for us today. And can you tell us a little bit about your practice?
Sure, thanks, Dave.
So I'm a privacy lawyer, and I'm based in Brussels with Hampton law firm. My practice focuses on all aspects of global and European data protection law. For several years, I have been advising clients across a range of sectors on implementing global privacy compliance programs, data transfer mechanisms, reporting data breaches, and I'm particularly focused on contract negotiation of data processing agreements. I'm also focused on technology issues, artificial intelligence, and digital marketing. Today, we're talking about data subject rights. This is a topic that is very interesting to me. It's very interesting for many of my clients, and I'm particularly excited to participate in today's program. Thanks for having me.
Absolutely, Anna. Thank you. And to round out our panel today, Gal Ringel is CEO of a fascinating privacy technology company called Mine, speaking with us today from Israel. Gal, it's great to have you with us, and can you tell us a little bit about your role over there and your company and your professional background as well?
Sure. Thanks, Dave, and hello, everyone. My name is Gal Ringel, and I'm a co-founder and CEO at Mine. Personally, I bring a decade of experience in cybersecurity offensive engineering, half of this time in the 80-100 unit in the Israel Intelligence Corps, released as a captain rank, as well as other various engineering roles. Before starting Mine, I spent around 4.5 years as a venture capitalist, working for two U.S. corporations, Nielsen and Verizon Ventures, where I invested in 20+ early and later stage startups in Israel, deploying a total of $15 million in those companies. Security and privacy are my top priority for the last 15 years. And I founded Mine with two other co-founders 1.5 years ago with a clear mission to empower millions of people worldwide to discover and manage their personal data online for minimizing online exposure and avoid digital risks. We do that by making privacy regulations easy and accessible to everyone, and we call it the future of data ownership. I'm looking forward to sharing the consumer voice during this panel.
Terrific. Thanks so much, Gal. And with that, as you can see, we have a breadth and wealth of expertise and experience here. So let's get started with the conversation. And for that, I'm going to turn it over to Anna. Anna, the stage is yours.
Thank you very much, Dave. Before we start this presentation, I would like to explain what issues we will talk about today. So first, I'm going to give a short overview of the main issues that companies typically encounter when they receive data subject rights requests through automated third-party platforms. Moving on, Carolina will give you an update on the work that the EDPB is doing on data subject rights issues and how they collect feedback. Then Ulrika will speak to how to navigate and review data subject rights requests received from third-party platforms. And Gal will help us know more about how such platforms actually work in practice. So I'll start with the overview. As you know, the GDPR gives individuals specific rights: the right of access, rectification, deletion, restriction, portability, the right to object, and the right not to be subject to automatic decision-making. These rights are enumerated in the law. Of course, we are in the post-Schrems II situation where some companies receive questions from individuals regarding the data transfer mechanism, but this is not a GDPR right. Or what the GDPR says, and I'm saying this because there's some confusion, is that a privacy notice must tell individual how to obtain a copy of a company's data transfer mechanism or where to receive information. So out of the GDPR core rights, there is a trend to automate requests regarding the rights of access and deletion. However, it is not easy to automate the review process of these requests. An access request can be very broad, and the company has a right under the GDPR to request to specify the scope of the request. So there needs to be some communication with the data subject. On the other hand, the right of deletion is not an absolute right. It is subject to conditions, exceptions. Importantly, it does not apply
where the processing is necessary for compliance with a legal obligation or for the establishment or defense of legal claims. So in practice, we see an increased number of new services that offer data subject rights requests as an automatic service. They do give the possibility to data subjects in a simplified manner to exercise their rights through just a few clicks. But the issue is more complex. Of course, the GDPR does not prohibit third-party platforms from submitting requests on behalf of data subjects, but it also does not contemplate this issue. It was not how the law was drafted. So under normal circumstances, if you're a company and you receive a request from an individual, you will probably have your standard process to follow a DSR policy or internal procedures. The first thing you would like to analyze is whether you're a controller, because the obligation to respond to a data subject request applies to the data controller, so not to the processor who has cooperation obligations. So you would seek to acknowledge receipt of the request if it is addressed legitimately to you. Review the request to assess if it's, of course, permissible, evaluate its substance, verify if any exceptions apply, and once you're satisfied, you'll tell your teams to collect the information and respond to the request with your help. The GDPR gives you 1 month to do all of this, which is a tight time frame for global complex organizations. But if it is a normal individual request, you probably know how to handle it. But one day, you receive an email from a third-party platform that may look like this one in this redacted example on this slide. You'll note it comes from a no-reply email address. It asks you to follow a link to provide data about a data subject to the platform. It claims that the individual authorized the platform to send you this email, and also the request is extremely broad, covering all your brands and subsidiaries. You spend a few days thinking if this is actually a spam. You talk to your lawyer, your boss, you wonder, this does not look like a normal DSR that we receive. What to do? A few days later, more emails come in from a different platform. They'll ask you to delete data about data subjects. You don't even know if you have data about this individual, and even if you're a controller of this data, because the email does not provide any information. The request claims that the data subject has any possible rights under any possible laws of the world, including but not limited to the GDPR, the CCPA, and so on. You think, what law applies after all? How am I supposed to verify what exceptions are applicable? So you think, let's just tell my team to delete the data. You call the IT department and they tell you they must follow specific records retention schedule, so they have concerns about the deletion. You then call the legal department and they ask you, are you sure we don't anticipate litigation with this person? So what to do? You have many requests on your desk. You have 1 month to respond if the GDPR applies, and you have many questions. Is this a legit request? Am I required to respond? Why did I receive 100 requests overnight? Should I provide my personal data to the third party? Should I delete my customer's data without even hearing from the customer directly? Do I even have a process to operationalize all of this? And often, but I am a processor, I don't interact directly with the data subject. How did they address this request to me? These are all very good questions, and we may not have answers to all of this. But it does address the situation that we do need guidance. So for me, there are specific legal issues that are associated with these requests from third-party platforms. To respond to such requests from third-party platforms, you must be able to verify the identity of the data subject, which will probably follow your normal process to do. And you must be satisfied that the data subject is the one who says he is. Importantly, you have to verify the authorization of the third party so that the individual indeed wanted to authorize the third party to submit a rights request on his behalf. Personally, I do not think that copying an email address of an individual in an automated and pre-formulated email is sufficient authorization to act on the individual's behalf because of two reasons. One, authorization rules vary by jurisdiction, so sometimes a power of attorney is required. And two, because someone may use someone else's email address in a fraudulent manner. This can be solved by taking measures to prevent this, but it's definitely an issue to consider for how to sufficiently set up an authorization process in the platform. I think regulators should give us clear guidance on a number of issues and also how to verify jurisdiction in broad requests that come in. And they typically just do not mention match apart from an email address. Also, we do need guidance on what is reasonable for a controller to undertake in order to respond to the request. What is a reasonable amount of effort that they should put in reviewing the request and be satisfied that the request is legitimate? Should they respond directly to the data subject? Sometimes the company that receives the request has direct relationship with the data subject, but sometimes it doesn't. So it is tricky how to respond. Obviously, we should be thinking of what is a sufficient authorization, and if the controller is required to respond, or if response is provided voluntarily to these platforms. An important issue I want to flag is liability. So what we want to avoid is specifically with a request for access to data, is that the controller, thinking that it must respond to a request from third-party platform, uploads customer data on a third-party platform that it turns out to not have the appropriate authorization. So would that be a data breach? The jurisdictional aspects, as I mentioned, must be clear. It takes a tremendous effort to analyze if rights under certain laws apply. And simply providing an email address without further information in a standardized email format, for me, does not explain why GDPR applies. With these thoughts, I'd like to turn over to Carolina, who will give us an update on how the EDPB thinks about data subject rights and if this particular issue has been more closely examined. Carolina, now over to you.
Many thanks, Anna, for this very comprehensive presentation. I hope you can all hear me well. Indeed, as I will just start with a little bit of an overview of the work done in general by the EDPB. As many of you may already know, the role of the European Data Protection Board is mainly that of ensuring the consistent application of the GDPR. And just as a little refresher, the EDPB is an independent European body composed of the national data protection authorities of the EU and of the EEA and the European Data Protection Supervisor. So it is important to bear in mind that the EDPB is not in itself a regulatory authority, and it doesn't replace national data protection authorities. Supervisory authorities are national, they are independent, and they are close to the citizens, and they are the ones who have the powers and means to apply the law and take enforcement actions, including fines and so on. Also, the EDPB does not amount to an appeal body for decisions made at a national level, because decisions taken by DSAs are subject to review by national courts. In order to achieve the goal of consistency that I have mentioned at the very beginning, the EDPB issues several types of documents, including primarily guidelines and consistency opinions. And indeed, data subject rights are a crucial topic for us. We think there is a need for the provisions on data subject rights to be interpreted, applied, and enforced in a harmonized manner to the extent possible. This is why we have already carried out quite some work on this topic. I'm sure many of you are already familiar with several of our guidelines. We have a little list that you can see on this slide right now. And currently, we're working on a very important guidance document concerning data subject rights. During our event today, of course, we're focusing on data subject rights requests submitted to third parties and third-party platforms in particular. And indeed, this is one of the, I have to say, many issues that we're reflecting on. It is a practice that has been noticed and reflected on by our members at a national level, and it has been identified by the plenary of the EDPB as an issue to closely follow. So we're looking into it both through the experience shared by DSAs and by gathering inputs from stakeholders. More specifically, this issue has also been brought up during the Stakeholder event that we hosted in November of last year regarding the topic of data subject rights in general, which aimed to kickstart our work on the guidelines. It was actually one of the 3 stakeholder events that we organized during 2019, and more than 150 participants, including business and professional associations, NGOs, academia, and representatives from companies, had the chance to share their views and raise issues that, in their view, needed further clarifications. I can provide you with a little overview of the different interventions that we received on this particular topic during the event. More specifically, some participants raised the issue of which proof controllers should ask in order to verify that the data subject has indeed entrusted the third party with exercising individual rights on his or her behalf, and which specific steps should be taken by controllers to verify the identity of the data subject and of the third party. Additionally, some other participants mentioned the fact that when requests are submitted by third parties, controllers might receive heavy amounts of requests at the same time relating to many different data subjects, and this makes it quite challenging for the controller to provide replies within the deadlines. I think I'm echoing a bit what Anna has already presented a little while ago. Another issue raised was to whom the requested information should be provided. For example, in the context of the exercise of the right of access. So whether the information should be provided to the third party or to the data subject directly. Of course, the EDPB guidelines will cover many crucial issues relating to data subject rights. And at this point, I am not able to say how far this specific topic will be addressed. So this is something I cannot really share fully at this point in time, but I can assure you that the inputs provided today are definitely feeding our reflections, especially given our intention to include as many practical examples as possible, which applies actually to all of our guidelines. So this makes this event very valuable for us, and I'm very curious today to engage in a conversation about how these issues are being dealt with in practice. Also, I take the opportunity to remind you all that after the adoption of these guidelines, there will be the opportunity for everyone to submit contributions within the public consultation. So that will amount to another very important moment for us to gather feedback on whether, for example, our guidelines are indeed helpful to solve issues, or rather they, they need to be further clarified and so on. So just bear this in mind and keep an eye on the EDPB website And please feel free and more than welcome to send contributions. Then I would say that what is very interesting to me is that this practice that we're speaking about today raises the broader overarching question of whether and how data subjects are and will be in the future really able to effectively and fully exercise their rights granted by the GDPR in the digital world, also in light of the differences in the degree of digital literacy or digital education. And of course, these practices are not the only instance in which the relationship between the data subject and the controller can be in a way mediated. Because, for example, we can think of when there is a controller-processor relationship, and we know that the GDPR requires the contract or other legal act to specify that the processor will assist the controller by appropriate measures in fulfilling data subject requests. And as EDPB clarified in the opinion on the Danish SCCs, the level of assistance given by the processor can take various shapes and may depend on the type of contractual relationship and on the role of the processor for the particular processing operations. So as an indicative list, the EDPB listed 3 types of options to be broadly chosen by the parties and to be clarified in the contract. So the minimum level of assistance, for instance, would be to require the processor to just forward the request to the controller. But the contract can also go as far as requiring the processor to respond directly to requests pursuant to the instructions. So this is something that we provided some guidance on already. However, when we think of requests sent to the controller via third-party platforms, we are very often in a different situation because of, although in both cases we have an additional actor in a way between the data subject and the controller, I would say that the third-party platform is often not in a contractual relationship with the controller and rather seems to be providing assistance in a way to the data subject. This, of course, I'm saying this although the relationship between the controller and the platform, in this case, will need to be analyzed in the specific context. And on this, on the controller-processor relationship, I would like to take the opportunity to highlight that the EDPB has very recently adopted new guidelines on controller-processor, on the concepts of the controller and processor under the GDPR. And public consultation is currently open. So I invite you all, this is a kind of a side note, but you're more than welcome to provide contributions about that as well. But this is just a bit of a reflection to see how the interaction between the data subject and the controller can vary a lot today. And I think this is a very important development in general in how the exercise of individual rights is being dealt with nowadays. In terms of main issues to be explored, I think indeed it would be very interesting to find out more about the ways in which controllers receiving requests sent by platforms are ensuring that data subjects appropriately gave them a proxy or a mandate to exercise rights on their behalf, which indeed may also depend on applicable national law, which adds an additional layer of complexity. I also wonder whether platforms engaged in this field generally use the same way to provide proof of this horizontally, or rather the proof differs from controller to controller or across jurisdictions and so on. More generally, it is quite interesting to look at how to strike a balance between the obligation for the controller to facilitate the exercise of data subject rights based on Article 12.2 GDPR, and on the other hand, the duty to avoid disclosure of personal data to unauthorized parties, which would lead to data breaches and, of course, major effects on data subjects. Another issue that I would particularly like to raise is that the situation may be different depending on which specific individual right is being exercised via third-party platform, since different rights and different implications may arise from the exercise via third parties of each of the individual rights granted by the GDPR. So, for example, helping a data subject to exercise the right to data portability of access may lead the third-party platform to access the personal data at stake, whereas I would imagine that assisting the user with the exercise of the right to be forgotten might not entail this additional processing. So this is also something I think is worth reflecting on, and it might be interesting to distinguish this rather than maybe referring to the exercise of individual rights as a whole. This is it from my side. I would like to thank a lot again the IAPP for hosting this panel, and thanks everyone for the attention. I look forward to the rest of the discussion, and now I would like to give the floor to Ulrika. Many thanks.
Okay, thank you very much, Carolina, and thank you, Anna, for this background. Very helpful. So before we turn over to Gal, who is in the business of sending DSR requests on behalf of individuals, I would like to raise a few of the operational challenges that we, being on the receiving end of these third-party requests, experience. I only have one slide here today where I've just put down a number of challenges or questions that are raised, and I'll use that as a background, not go through it in any particular order, but I will touch upon most of them. I just want to give you a little bit of a flavor of our experience to date. I mentioned earlier that PayU is a global payment provider, and we receive payment and financial data from merchants. We help with the processing of that payment, and we do all the required checks. We have local payment databases. Unfortunately, there is no one magical global database where we can store all the payment data and just by a simple click find an individual who may be asking to have his or her data deleted. That would be great, but I think also, probably illegal in most countries. So that is one big issue when we receive these requests, that there's no, and I think Anna mentioned this before as well, there's no possibility for us to kind of see where does the individual come from. When we started to receive these requests from mine, for instance, but also from other vendors, we embarked upon a rather burdensome trip, I have to say. And I have to admit that through time, things have improved, but to a certain extent, but still leaves us with quite extremely time-consuming and laborious efforts. Besides the global versus local, situation, one of the main points is around the validity of the request. We've experienced a number of different approaches here. We could get an email from the vendor bluntly saying, hey, we are submitting this deletion request on behalf of individual X. Please go ahead. And that obviously poses some issues around powers of attorney and authorization and the like. So we need to start engaging and getting more information with the individual. Sometimes the individual is copied in the email, which is again sent by the vendor. Maybe, there's an argument that the individual is perhaps put on notice and they arguably know that they are sending something and that they have agreed to that, but it's still a little bit grayish. We also receive these requests directly from the individual, although sent by a third party. And then maybe there's more likelihood that we can, consider that there is not an issue of authorization involved because it comes directly from the individual. But kind of grappling with these types of issues, it's not always clear and clear-cut, and it requires some work. Other areas as well, besides the geography and the validity, it's also around the request itself. Sometimes, it can say, please delete this data that we have with you. It's very vague. In what context? When did the individual engage with us? Maybe the business or the company has a number of different business lines, right? And it's very unclear. What it often requires is that we need to kind of start engage, maybe with the individual himself or herself, or with the vendor to get more information, to also delay the timing and the response time within which the request has to be replied to. It's quite, it's not about one request or 100. It can be really a lot of requests. So it requires a lot of monitoring effort as well. And all companies do not have, full-fledged automatic DSR processes in place. And even if you were to have that, I don't think even the most elegant DSR tool is enough, because there is this back and forth that is needed, and it's quite cumbersome for the companies. And sometimes what we have also experienced is that we have been able to identify or to find the individual, and then we reply within the time limit, and we reply, stating that, for certain types of data we cannot delete it, but because we have regulatory requirements to keep them for a certain period of time, but we have gone ahead and deleted you from our marketing database, for instance. And then we get back replies stating from surprised users, I don't want you to delete my data, or I didn't know I had anything with you, or I have not engaged with you. So it's a little bit strange sometimes to engage in those types of conversations, and they have happened and do happen still. Another issue that we grapple with, and that is around, I think Carolina kind of touched upon that as well, that is the controller, right, that needs to reply to the data subject request. Many pay you, for a lot of our processing, we are a processor, could be a controller as well. But if we are a processor, how does that we have a requirement, maybe contractually, with the controller to, if you receive a data subject request, you need to let us know you cannot handle it, but you have to help us, but we need to handle it. But it's not that, and then it's not always easy, to Carolina's earlier point, to find within the timeline, with the little limited information you have, what controller customer or what controller merchant does this individual belong to. So that is another quite burdensome area where we need to put down a lot of effort as well. The timing obviously is also another important aspect. Data subject rights exist in different legislations. GDPR is one of them, and GDPR has a whole 30 days that we can, work with, and even more so, if this is extended. But there are other countries where we are active that have far fewer days than 30 days. There are 5 days in certain countries. There are maybe even lesser than that. So that also kind of, puts a lot of pressure on us, and really, wanting to know or be more, we have to put a lot of effort into really trying to figure out where this individual comes from and what's the deal, basically. And that has also, caused some concern. I think those are just a few of the different aspects that we are facing. But I think one of the main questions I have, and I think Gal will probably talk about that in his overview, is really how is it that we receive these requests? What is that? Because sometimes there are a lot of queries around that, and likewise in the interaction we have with the individuals, it's not always clear cut. So I think I will leave my remarks there and maybe have Gal, talk more about the actual journey, and I'll hand it over to you, Gal.
Thank you very much, Ulrika. It was really insightful. I'll try to address some of the questions that I see in the audience. So mine is a personal data assistant, enabling consumers worldwide to discover and manage their personal data online for reducing their online exposure and avoid digital risks. As you all know, in a hyper-digital world where we all lost control over our personal data online, mine actually powers a new future of data ownership by making privacy regulations such as the GDPR and CCPA easy and accessible to everyone. We think that everyone actually deserves having a choice and transparency over their personal data online. We do that by providing consumers a product that enables them to understand which companies have collected their data, what are the digital risks associated with it, and a way to reduce its impact by making privacy regulations accessible, specifically the right to be forgotten. So after Anna, Ulrika, and Carolina illustrated so nicely the legal, the company, and the regulator side of handling privacy regulations, I'm here to share the user voice around the whole process. After our users used mine to send more than 600,000 right to erasure requests worldwide in just 5 months since we launched the product. So, but before I dive into the details on how we operate and how the product works, I'd be happy to share a few words about our path to data ownership. So what is actually data ownership means? So it's all about accessibility to the asset that belongs to us, our personal data, and our free choice to decide what we want to do with it under the boundaries of different privacy regulations. But before we can all exercise our privacy rights, we need to understand what we're dealing with. Or in other words, we need to understand which companies hold our data, what do they do with it, and what is the digital exposure associated with it. So therefore, the first step when a user signs up to mine, he can immediately see a high-level overview of his digital footprint, including first his digital risk level. We calculate it by the type of data he or she provided to the companies in the past, the different industries, the previous data breaches and privacy scandals, and more. And obviously that ranking is improved over time. Second, how many companies hold this data? We discovered that the average footprint consists of 350 companies holding the sensitive data of the user, and that number keeps growing with 8 new companies a month. This means that our footprint is highly dynamic and keeps changing all the time. And lastly, they can see the breakdown of the type of data those companies have collected by 4 types of data families: identity data, financial data, online behavior data, and social network related data. Lastly, by clicking See My Footprint, the user can then see the list of companies and navigate his digital footprint for the first time. This is a really mind-blowing experience. Here, the user can see the companies that we have found for him, including their names, logos, industries, and the type of data they collected, and also the risk level associated with that. So how do we construct the user digital footprint? We discovered that over 90% of the significant online interactions and data exchanges we all doing online leave traces in our email inboxes. For example, when we sign up to a new service, we get a welcome email. Or when we purchase something, we get also an email, your invoice from Amazon, your flight ticket from United, etc. So we have developed a non-intrusive AI, very accurate, that helps the user find those interactions in his email inbox and reflect it back to him. We do that by only processing the email subject lines and email metadata, and we do that in memory without processing the content of the email. In fact, we don't keep any trace of the emails in our database, and we committed to collect the bare minimum of personal data since we just don't need it and it's not our business model. So how do we know what data companies are collecting without processing the user data? We developed another AI that automatically analyzes privacy policies of the companies to understand what type of data they collect and what do they do with that, sharing, selling, etc. And then we match it to the interaction we identified in the user inbox. This is also a very accurate technology, and we already did it to 4 million digital services online. So now that the user understands his digital footprint, he can have a choice to decide which companies he wants to keep and which companies he wants to delete. We call it reclaim. And this is how the user actually exercises the right to be forgotten from different services. Here, I'd like to note that every user at mine is sending the request themselves. So we are not deciding for them or acting on their behalf. And this is to solve most of the issues that Anna shared earlier. So every time a user wants to send a deletion request, a right to be forgotten, it gets authenticated and verified through his email inbox. We use OAuth 2 protocol to verify that the user is the owner of the email inbox. As well as the user needs to mark a checkbox that he understands what is going to happen for every single request. You can also see the DSR that is going to be sent before approving it. And we also limit the sending to 1 request per company. So users can't spam companies through mine. The email is then sent directly from the user inbox. As everyone mentioned here, originally we sent the email directly from the company inbox as a third party, but after companies have requested us to send the email directly from the user inbox for verification or authorization purposes, we actually listened and changed it quickly. We also added a data evidence to the email, to the DSR that we are sending to help the companies validate the request itself. And we are also here to work with companies and help them operate faster around those requests. The next stage is that in order to help our user make informed choices about where they want to keep their data, we provide them with a lot of context about each company holding their personal data. In the left screenshot, you can see how Spotify, for example, is shown for a user that has a premium account. We show the exact data that Spotify is collecting, what is the industry breach potential based on the historical data in use, but also what is the risk of data exposure in this particular case. And lastly, we offer our users a full monitoring on the entire compliance process from the initiation of the request, the email that the user is sending through our platform, all the way to the completion of the request. Here we are using another AI that we developed to track the company responses in different phases. And as a smart data assistant, we notify the user each time there is an action required on his end, and each time the process has been completed successfully. It is important to note here that mine measures the entire compliance process with every company that the user sends a request to. So we have a unique insight and visibility into the whole privacy industry. And soon we're going to launch a new mine index to showcase a worldwide privacy compliance ranking, which is going to be really interesting. So last slide, how our companies are reacting to our requests. So here I'd like to mention that since our official product launch, we are in discussion and working together with hundreds of companies worldwide to improve our approach, but also to help them compile to fulfill those requests in a more efficient way and reduce the time spent on their side. We actually strive to create one privacy standard on how users should approach companies and to create a bridge between them. So I welcome all of you to reach out with any suggestions and we'll make it happen. So after sending more than 600,000 right to erasure requests worldwide, we learned a lot on the compliance process itself. And currently, it seems like 37% of the companies have completed the process successfully. Around 26% of the requests are still in process because, for example, under the GDPR, companies have up to 30 days to comply. Overall, we see that around 60% completion rates of requests. And on average, we see that it takes companies between 14 to 45 days to complete a GDPR request and between 30 to 60 days to complete a CCPA request. Lastly, we measured at 23% of the companies that did not reply to the request yet. Some are ignoring and some just taking their time. And lastly, this is the interesting part, 14% of the requests of the companies actually approached to us to better understand how we operate and to suggest ways how can we improve the process. So to summarize, we have learned so much on the user-company privacy relationship, and we are looking for more ways to connect between the two to create a better privacy future. And we are also helping many companies to differentiate between data controller and data processor requests to block them at source and forward them only requests that are valid. So I welcome everyone to go to SayMine and check it out, saymine.com, and also to reach out with any questions. That would be all. Over to you, Dave, for starting the Q&A. Thank you.
Terrific, Gal, and thank you, Anna and Carolina and Ulrika, for your pieces as well. Excellent discussion, and we do have a few minutes left here now for some questions. We have a number of good questions in, so let me get right to them because I want to get to as many as we can in the time that's remaining. Gal, this first one over to you. You may have touched on this, but I'm going to ask you to maybe elaborate a little bit and generalize. And it's this, SayMine description of the service states, in quotes, we may conduct an identification procedure to validate your identity and formulate the required authorization to act on your behalf. So not all requests mailed have identification verified, so we send out a form as if a normal email request was received to the GDPR data subject. This normally is the end of the subject access request. Can you comment on that question?
Yes, thank you, Dave. So we actually need to update that specific paragraph because to date we are verifying every request that our users are sending, and we do that based on the OAuth 2.0 email authentication. So we are verifying every user, every data subject as the owner of its inbox. So we're actually doing that for all the requests. So thank you for pointing this out. We will actually amend that.
Great, and it's a terrific reason for these dialogues, these conversations, for us all to be aware and improve. So thanks for that question from the audience, and thanks, Carl, for that response. Let me move on now, and Anna, direct this next question to you. I think it's quite a good one, and and I would be curious to hear if other panelists have a response as well. And here's the question. Would it be appropriate for a controller to refuse to respond to one of these DSR platforms unless the DSR executes contractual terms, making guarantees to and indemnifying the controller? Seems like a very reasonable reaction from a controller to err on the conservative and safe side on behalf of the data subjects and ask for that, although I'm going to guess that that's maybe difficult to receive that kind of a contractual obligation. But Anna, what are your thoughts about that?
Thanks, Dave. I think this is a great question. We may not have a clear response, but it does, make us think about it. So On the one hand, the controller will want to have some guarantees that the platform has checked everything they needed to in order for the controller to feel more comfortable that they will not violate the law by complying to the request. So it will take burden off the shoulders of the controller if they know identity has been checked, authorization is bulletproof, etc. However, I do think that from a negotiation point of view, it will be difficult to impose such contractual obligations to third-party platforms. Gal might be more appropriate to respond to this since he represents such platforms. But as a lawyer, I would think it will be difficult for a third party to commit to indemnify potential violations because in this context, because they would acknowledge that their platform has legal gaps on the one hand, and on the other hand, they would not know the scope of their audience. So the platform, if I understand correctly, or this type of platforms anyway, allow individuals to send requests to a number of companies that the platform does not have a relationship with. So they do not know with whom they would interact and promise to indemnify. So I think it might be a little bit difficult, but it does show us the importance of the controller wanting to feel comfortable in order to respond to the request received by the third platform.
Terrific. Yeah. You mentioned, Gal, did you have any follow-up comments on that?
I think we have another question regarding that. I think Brooke was asking a similar one, but I think Anna answered that nicely.
Okay, fantastic. Let me move on here and ask about, let's see who, this one is for Ulrika. The question is, if you delete data without the data subject recognizing he, she has sent a request, would that be considered a data leak? What are your thoughts there?
Yeah, no, I saw the question, and it's an interesting question. I don't know about a data leak, but obviously there is something. There is certainly a maybe an argument for it, or that you have done something with the data that you were not supposed to do. You know, so there's some kind of repercussion. Would it be a data leak per se? I'm not sure, but certainly, you know, some kind of issue is at play. I don't know what Anna would think, you know, would that be characterized as a data leak per se? Maybe you can offer some additional comments on that.
Yes, Anna, what would you, thank you, Ulrika. Anna, would you have any comments there?
So if you would delete the data in response to the request, well, it's not exactly a data breach, right? Although, you know, unauthorized or illegal deletion of the data per se could be. But here, I think what is important is to verify that the request is legitimate. And if you feel comfortable that it is, then, you know, deleting the data would be justifiable in terms of arguing you did the right thing. I think the problem is where you feel unsecure about whether the request is legitimate, and if you have concerns about it just because that specific platform may look weird to you for specific reasons, that, you know, they are things you would want to push back than to take a risk to delete the data.
Thank you for that, Anna. And I would like to make mention of the fact that we are now at the top of the hour. However, and so if some folks who are live with us on the program need to drop, we fully understand. We're going to take just a couple more minutes and go beyond our allotted time with the agreement of the panelists to answer just a couple more questions because we've got some really excellent questions that have come in. So we're going to take time to do that. If you have to drop now, please know that we're making a recording, and you can always come back and listen to the recording to catch up with what you've missed. So let me move on here. And this one for Carolina, maybe be curious to hear your reactions to this one. Some of the data subject request platforms are trying to leverage the data subject request to pressure controllers into signing up for the platform business-to-business compliance services. And the question is, do the panelists think this is ethical? So this is about the interplay between these platforms and the controllers and the marketplace. Does that make sense to you, Carolina, and do you have any response to that?
Thanks, Dave. I was actually, reflecting on this question. I am not sure that this is the kind of issue that specifically pertains to the interpretation of the GDPR itself. So I am not sure if this is within, my own competence. From my personal perspective, I understand this is a very complex situation to handle for controllers for sure. And indeed, I completely understand the complexity behind this situation that I see more, however, as a question of, contractual power or maybe imbalance of power. I'm not sure if this pertains specifically to the interpretation of the GDPR, if you know what I mean. I'm not sure if the other panelists agree with me.
Yeah, Anna, have you seen any of this happening in terms of what you've witnessed out there in terms of these platform requests on behalf of controllers and that relationship between the two entities?
Yes, I think there are some of these third-party platforms that their business model actually is to help individuals submit automatic requests in large numbers. And they're reaching out to companies, helping them out to find out how to respond to them. I'm not sure which platforms these are, but, I think it's a little bit tricky to take a position on this topic. On the one hand, is the business perspective that perhaps justifies this for certain, businesses. But on the other hand, it creates a lot of burden for companies and then also need help to help them solve it. It is tricky. So I wouldn't say it's unethical, but it's definitely, it creates imbalance of powers. On the one hand, you help individuals. On the other hand, you want to help companies respond to the request of individuals. I don't know what to think about it, but I do know that it exists as a business model.
Okay, thanks. And Anna, for those of you out in the audience, we're having a little trouble with hearing your microphone. Perhaps you can see if you can adjust that. Gal, over to you next. I have two similar questions for you about the platform and how it works, and this also has to do with it, I would think, in general, platform requests and the interplay between platform requests, the controllers, and the data subjects. And here's the question. If companies are responding directly with customers to complete their deletion request after SAMINE initiates the request, how does SAMINE know once the request is completed? So it's kind of a triangle of communications going on here, Gal, and we have another question that's similar to that in the same vein.
So this is actually a really good question because this is something that really differentiates our product. So every time a user wants to initiate a request, since we operate as a data assistant within his inbox, you can think of us, you can think about as a privacy CRM. So each time a user wants to initiate a request, the request is being sent directly from the user inbox. And since that point, every time the company replies directly to the user, since we are letting our users to monitor the entire process, we are also processing with the same technology the subject lines of all the responses of the companies that are going directly to the user as part of the deletion process. So each time a company replies, we actually track that and we notify the user. So this is how we know when the process is completed successfully, or when a data subject needs to reply to the company. So from our perspective, the user is doing all the communication directly with the company. We are not a third party in between.
Okay, great. That's helpful, and I have a related question, and I'm going to ask this of Anna and Ulrika, and this unfortunately will need to be our last question just because we're running out of time. I don't want to be respectful of everybody's time. And it's this, and I think it's quite interesting. Is it legal as a controller to respond to the user when presented with a MINE request, or for that matter, any other third-party platform, that they need to submit a request through the controller's DSR web form? So I'm going to generalize this and say it's a little bit of a tricky legal situation, it seems, when a platform responds to a controller with requests, and the controller then wants to verify that, so it goes out to the individuals. But what if it was an illegitimate request? That puts the controller in an awkward position of reaching out to data subjects when the data subjects themselves did not reach out to the controller. So Anna, maybe your kind of response to the legal aspect of that, and then Ulrika, I would be curious to hear your thoughts about how to respond as a controller trying to balance these obligations and respect the users themselves. So Anna?
So if you're a controller and you receive a request from a third-party platform, and I will not speak to mine because I don't really know how it works, apart from the presentation today, but I will say this. If the individual is copied or the email address is provided in the automated email, and you verify your records and you know this is a user of yours, nothing prevents you to reach out to them directly outside of the platform. In some cases, it might even be a good idea if you have doubts about the lawfulness of the request, and ask them, hi, you're a customer of mine. Do you really want to receive the data or receive this request? And then let us know how to proceed. That gives more power to the data subject to verify the request. So is it illegal to respond directly to the data subject? It's not illegal. Nothing really, unless guidance says otherwise. I don't think there's anything that in the law that requires you to respond directly to the platform, although it might be easy to do so. And I can think of situations where a company receives 100 requests overnight. If you would engage in individual conversation with each of these individuals after you verify you indeed have a relationship with them, might be a little bit difficult from a practical perspective. So nothing prevents you to ask the individual to go through your standard DSR process if they want to submit the request. I think we got a comment in the chat box about this similar point, saying that some companies actually this is what they do, especially when they don't feel comfortable that the identity of the individual has been verified, and they send their standard form, hoping not to hear back from the individual. So for them, this is where the process would stop.
Terrific. Thank you, Anna. And Ulrika, I know this is a difficult and tricky situation and probably needs to be handled on a case-by-case basis, but as a controller receiving requests from these platforms, would, from a customer service perspective, it must be hard to decide whether to reach out to individuals directly for verification of these platform requests. But, what are your thoughts there just in general?
Yeah, I mean, it's if you have, I would say if I were the controller and I received a request from via a third-party provider, and there is a mentioning of that individual, and you're able to reach out to him or her directly, I would probably yeah, it is tricky, and it is on a case-by-case basis. So maybe this is not a general answer, but I would, I would go for, sending an email to that individual, maybe copy the I don't know if it's the company who has sent it or the vendor, or, we have seen both scenarios. So, because that is also, that's one way of dealing with it, because that was the question. I don't know if I misunderstood the question, whether the controller would reach out directly to the individual.
Yes, no, that was exactly the question, and that makes good sense. It seems like it would be to err on the conservative side to receive authentication from the individual at the expense of perhaps bothering the individual, reaching out to them,
exactly.
After a platform head. Yeah, that makes good sense. All right, terrific. Well, want to be respectful of everybody's time, and unfortunately, all this discussion could certainly be carried on, and obviously this is a very vexing issue and one that I'm sure we'll be addressing somewhere down the line. I wonder if there will be some, cases brought before the courts with regards to this work, and new technologies I'm sure will continue to develop, like the ones that Gall's company have developed. So fascinating issue. Again, I'm sure we'll be revisiting in the future. So I do want to thank all of our panelists for providing their experience and expertise on the program today. Ulrika, thank you so much for sharing your time and energy with us today. It's great to have you on the panel. And let's see. To close now, so Ulrika, Terlina, Anna, Gal, thank you all very much. Really appreciate your time and sharing your expertise with us. I want to also thank those of you in the background here, specifically the team at the IAPP, Gracelyn, who has been helping us to organize this panel, and Jordan and Rachel and others, and all of you for spending some time with us today. Thank you for building a little time in the calendars. I hope that the program met your expectations and provided you with some interesting information. We received a lot of questions, and we will do our best to export those and perhaps see if we can answer some of them in writing. So keep an eye out on the IAPP website if we're able to do that. And I wanted to ask, before you drop off the program, if you're still with us and have just a few minutes to take a quick survey, we have a very quick survey built that allows you to give us feedback about this program in particular, but also IAPP web conferences in general. We'd love to hear from you, what works, what doesn't work, how can we do things better. And importantly, there's a field in the survey where you can let us know what topics and issues you'd like to hear about on future programs. So if you could take literally 2 minutes, click on that link and give us a call or give us your information and your feedback. We would very much appreciate it. And as I mentioned at the beginning of the program, if you're an IAPP certified privacy professional and you have your certification with us and you signed up with this for this program on our website, then you will automatically be granted 1 CPE credit toward the upkeep of your certification. You don't need to do anything. If you're watching this as a recording and you'd like that CPE credit, you can certainly apply for that using a form on our website. It's very easy to fill out, and we can get you that credit. If you're an attorney and you're here in the United States and you're wondering about continuing legal education or CLE credits, you can apply for those credits through an easy-to-use online form. But you should contact me directly, and I can provide you with some information about who to contact in our team for that certification. We can provide, for that application, we can provide some supporting materials for that if you need them. The way to contact me is best through email. I'm dave@iapp.org, so feel free to send me a note and reach out. And with that, thanks very much. We've gone a little bit over, but hopefully it's been useful to all of you. Appreciate your time today, and so hope to see you on a program in the near future. And with that, I will take us to a program close.